Good afternoon, everybody. Today is Wednesday, February 18th, 2026, and you are watching a committee, and it happens to be the General and Housing Committee, so you can turn it off if you thought you were watching something else. What we're going to do now is we're going to walk through and have a discussion of H 459, and we're going to take testimony. It's an act relating to the Parental and Family Leave Act. Then we're going to take a break, and then we're going to have an introduction of H 858, which is a courtesy that we essentially extend to every author of a bill that comes before us. And then mid-afternoon before the floor, we're going to have a budget discussion because we owe a letter to House Appropriations about our priorities. And we have a draft letter, just as a very rough draft to begin the discussion. So let's start with H 459. We have first our counsel, Sophie Fatney, and then Megan Sullivan, who's government affairs for the chamber, and then Johanna Grafenfried with BBSR. So, Sophie, take it away.
Good afternoon, Sophie Zadatny for the Office of Legislative Counsel. Is it right if I go ahead and share my screen?
Please.
Is that loading for everybody? So this was originally a short form bill, so this is now a standard form bill. And what it does is it adds a provision to the Parental and Family Leave Act that deals with running workers' compensation leave and Parental and Family Leave Act concurrently. So I'm just going to move forward to the additional language.
Sophie, why don't you just go back slightly and say what the FMLA does?
So FMLA is a federal medical leave act, that's at the federal level. And then we have the Parental Family Leave Act in Vermont. And so the Federal Medical Leave Act essentially sets a floor, and states can be more protective, more generous in what they do. And so the Parental Family Leave Act, not 100% of it, but for the most part, provides greater protections than are provided under the Federal Medical Leave Act. So what this bill is proposing to do is that currently employers, if somebody's out, and we went through this last week with, I did a quick PowerPoint presentation on it. If you qualify, you have a workers' compensation injury, injured at work, you're out on leave while you're recovering from your workers' compensation injury, and that injury also qualifies as a serious health condition under the Parental Family Leave Act, employers can currently run that leave concurrently. So you may be out, say, for 8 weeks on workers' compensation. They can run the clock on your eligibility for unpaid Parental and Family Leave Act at the same time. So you would use up 8 weeks of your PFLA entitlement, which is 12 weeks of unpaid leave. And what this bill seeks to do is to provide that employers that employ more than 50 individuals who are employed for an average of at least 30 hours per week during the year shall not count an employee's leave for a compensable work-related injury or illness under the workers' compensation statute as unpaid leave. So this would prevent employers that have 50 or more employees from being able to run those two leaves concurrently.
Is there a maximum, just a couple of basic questions to get on the record. Is there a maximum leave for workers' comp? Or is it just total, whatever the injury demands as per a doctor?
Yeah, I mean, workers' compensation is a whole other animal unto itself. It's usually over in House Commerce and Economic Development. But you could be out on leave for a considerable period of time, and the workers' compensation statute provides that if you are able to go back to work within 2 years, that you're entitled to be reinstated to the next suitable job that's available. So we do provide under Vermont law, reinstatement for individuals with workers' compensation, and you're also under Vermont law protected from retaliation, if you're out on workers' compensation leave. So again, not all states do that. Some states do not, don't provide that job protection as part of their workers' compensation. So again, there may be reasons why you would want to run your family medical leave and your workers' compensation concurrently, because FMLA essentially is a job protection. If you're out on leave, it essentially is enabling you to return to your position.
To your actual position.
Right. I mean, there are some parameters around that, like if you're in a unique position, etc. I mean, there is language in the Parental Family Leave Act around reinstatement.
Whereas in the workers' comp, it's the next suitable.
Right, that you're able to do.
Right. Elizabeth, you have a question.
I do, thank you. I've got two very quick questions. The first is workers' compensation limited to or available to companies only with 50 employees or more?
No, workers' compensation is a whole separate statute under Title 21. So yes, workers' compensation is a completely separate animal, and it covers employees that are injured on the job.
And the second question is FMLA limited to companies with 50 employees or more?
So the FMLA is, and that's why this version of the bill includes 50 employees as the threshold amount. The Parental and Family Leave Act has a much lower level to be eligible to take the unpaid leave. So there are differences there.
I'm sorry, say that again.
So if you're an employer and you have 10 employees or more, or 15 employees or more, then eligible employees are entitled to coverage under the Parental and Family Leave Act. There's two different thresholds. So this is creating a third threshold under the Parental and Family Leave Act, which would be 50 employees or more than 50 employees for this provision to apply, where you would not be allowed to run your unpaid leave concurrent with workers' compensation leave.
I'm sorry,
Right.
Sophie, can you just say that one more time? Is FMLA limited? What is the floor of FMLA for?
FMLA is 50 employees or more. And then again, the employees have to work a certain number of hours, and then it's within a certain radius. It's a 75-mile radius. So there are eligibility requirements to be an employer that's covered by the FMLA. The PFLA in Vermont covers a much greater number of employers, because the threshold to be a covered employer is much lower. It's 10 employees or more for one kind of leave and 15 employees or more for the other kinds of leaves under the unpaid, under the PFLA.
And then, so 50 is really, it's a number that is intrinsically foreign to each act. And it's basically creating a different threshold for this non-concurrency clause.
Right.
Okay.
That's really just a placeholder based on the conversation with the committee last time. I mean, it could be a different number, it could be a higher number, it could be a lower number. But what was suggested by the committee last time to start with was to look at the FMLA threshold. So that's why it has 150 employees. That's the threshold. In that.
Committee questions of Sophie, please.
To start, not necessarily a Sophie question, but a committee question, or for you, Chair. Should this pass through our committee, will this need to do a drive-by in Commerce?
I think that's a good question. I would think I would have to ask Chair Marcotte. I think it's worth asking.
I would assume I'm here. I'm alive.
Hey, Emily, my God, you're heroic.
I know. I would assume probably it would. Or
Okay.
should.
Yeah, I think that's just something to know.
And so if you remind me, in the Senate though, they don't have this, right? This is our own thing up here we're doing, right?
Yeah, there's no
Companion,
on the
right?
Senate.
Because they have both jurisdictions. I just couldn't. Okay, this is our own thing. Thank you.
But this bill amends the FMLA.
No,
It
the
meant
parental,
parental and family
The
leave.
F is
Parental,
federal.
the Vermont,
the Vermont parental.
yeah. Which is why it's here,
Yes,
Yeah.
right, but it implicates the workers' comp, which, okay, got it.
it doesn't diminish anyone's rights under the workers' comp statute, but what this would do is it would be protective of employees with large employers who have workers' compensation injuries. It would enable them to still have access to 12 weeks of unpaid labor of unpaid leave, whereas right now, those leaves can be run concurrently.
Do you still have a question, Elizabeth?
I have a different question.
Please, ask it.
I don't recall why our committee set the number at 50 employees. Do you know what the most common practice is among states for this?
So this would be unique. There is not a prohibition on running leave concurrently in other states. And the reason the 50 was picked was because that's the size of employer that in the FMLA, the Federal Family Medical Leave Act. Again, that's a policy decision by the committee in terms of if they want to move forward with the bill, if that's the right number or a different number could be used.
Thank you.
Do you have any more questions? I thought you said you had some. Okay, go ahead, Nora.
Yeah, thanks. So as I feel like we've, in terms of impact, if it's a policy question, then we're talking about like, who would this impact, right? And so there are not that many 50+ employers.
I don't know the numbers off the top of my head. I know last time when we talked about the bill, there was considerable concern around small employers.
Right, so this would prevent the anybody with 49 employees.
So this would allow, it would
Left.
continue to allow smaller employees to run these concurrently.
Right.
Any further questions? Do you have a question?
I'll say, oh,
Emily, do you have a question of Sophie before we move on to our first witness?
it's more just to the committee, I would say. For me, I would like to look at the policy. This was just a placeholder number. I'd like to look at the policy issue and then decide on that number, if that's right, I would say. I may not want to have any number. Right?
No. Well, I think that's an issue. I mean, think about, Emily, think what kind of information you need about that at the, in terms of what we need to know. You know that the 50 just comes from it's an artifact of the number used by the FMLA, so.
Right. And in the research that I've done on some of these businesses that are doing things of this nature, they are larger, right? But I've also heard folks say, well, why should anyone be allowed to do such a thing? So I just want to keep that in mind as we, I'd rather hear about the testimony first before deciding the number part.
Great,
I think
yes.
I'd like to hear from schools and school educators and school districts, I guess, or whoever, but or just to hear how that would impact the workers and right, because I think that wasn't there a consideration about whether all the like people that work only in the do not work summer hours, whether this excludes all of them?
So there is a bill currently in the Senate, and I believe you have one on the wall in here as well, that would include teachers. So what happened in the session last time when the changes were made to the parental and family leave act was added in on the Senate side to cover air crews that are covered by the FMLA, because they wouldn't otherwise qualify under the PFLA based on the number of hours worked. And because they have very set hours, they have a special exemption under the FMLA to scoop them in. And so this session, there's been a request on behalf of teachers to make sure that they get the same consideration.
Yeah.
And that the our Vermont Parental Family Leave Act incorporates the federal definition of teachers. So if you qualify under the federal Family Medical Leave Act, you would then also qualify under the PFLA. So that's a separate bill, again, that you have on the wall, and is also in Senate Economic Development.
But so would this also affect that same population of, say, like,
If the other bill passes, that would then incorporate teachers under the PFLA, then yes. If you then also pass this bill, then it would impact.
But right now, our teacher's not included because they don't work a full year, or
Right, it's based on, yeah,
it's based on number of hours worked, and they don't,
so
because
they
they have
just
the
have
summer off.
special, right, they just have the special language under the FMLA that brings in,
But that it's not under the Vermont PFLA.
right.
Okay.
Elizabeth has another question.
Who has a question? Elizabeth, you have another question?
I do, thank you. First, I believe, I don't know whether it's changed, but when I last was a contract negotiator for our school board, it depends on whether teachers are paid year round or not. It depends on their contract. They can either opt in or opt to be paid year round, or they can opt to, it's contract by contract, or it was however many years ago. I don't know whether that's changed. But what I would like to know is there any data about existing about how often this occurs? Thanks.
How often watch it goes?
How often?
The simultaneity.
Yeah.
I don't know. I mean, I think often employers will run them both concurrently when someone's out on a leave that qualifies under both workers' compensation and under the PFLA. And that's permitted to do that. So, but the actual number of employers that do that, I don't know that.
Yes.
I just want to say that as a person who had this happen to them, I think that it would be good to have somebody in as a witness who had to return to work earlier than they should have as a result of this taking place, and like whether they were able to be productive at work or just be a body in a seat. Thanks.
Yes.
I just have like a few thoughts and questions. I'm not an expert in workers' comp. But from my understanding, yes, an employer continues to hold the premium for the employee while they're out on workers' comp. However, is that indefinite? Like, I feel like,
So
from my understanding, it's not indefinite, but like, where is that?
I think it varies on a case by case basis. So, if you reach, getting the language, final sort of medical improvement,
Yeah.
you're not going to get any better. At that point, then there's a determination, whether you can return to work, whether you need vocational rehabilitation to, develop other skills, but for other positions. There's, right, so you might have a permanent impairment where you get, paid for the permanent impairment. There's replacement wages, that's usually 2/3 of what the employee was making pre-injury that you receive while you're out, receiving treatment. So it's very, case by case specific. The reinstatement provision is up to 2 years, so that you have the right to be reinstated when that's a suitable job, that lasts for a 2-year period.
My other question is. It's not a data point, Rep. Burrows, but just, I mean, for me, in my practice and how I've, like, for me, best practice would not be to run them congruent. I've never done that. I would never do that. It might be dependent on the workers' comp issue. But I'm just thinking of one of the things that I've had to deal with is we live in Vermont, somebody slips and falls on the ice and all of a sudden they have a stiff neck. So that's going to be covered under workers' comp. But I can almost guarantee that a doctor probably would not say, yeah, this person needs to be out. This is going to be significant enough for FMLA. So I just,
I'm sorry, did you say it would be workers' comp, but it wouldn't be FMLA?
I can see a very real scenario where it wouldn't be covered that way. It's, and, sometimes workers' comp a doctor will say, I'm going back to the slipping on the ice, the employee could come in half days. So then workers' comp covers their medical expenses and the half day that they were out were 2/3 of the half day. And then that employee came in like the afternoons. But their doctor couldn't say like, yeah, goes so far to be covered as FMLA.
So under workers' compensation, you can have light duty, so it may be that you
Yeah.
can't lift heavy things, but you could, work in the office doing something that's more administrative. I mean, that's part of it. The goal is to try and get people back, because actually my understanding is people actually recover more quickly if they're actually back in work rather than sitting at home feeling sorry for themselves if there's something they can be doing.
And the other thing I just want to bring up, and again, like not really a question, but just something for us all to think about is if I'm in a position, I start at 9 a.m. on a Monday, I'm brand new baby employee, and then I slip in a puddle in the hall at work, I'm automatically covered by workers' comp, or not automatically, but like I become eligible when I start working, whereas I won't be covered by FMLA or PFLA until a year after or the 1250 hours. So there are just other scenarios where like these two
Why don't
go
we,
hand in hand.
maybe what we ought to do, I'm certainly willing to have you comment, but I'm wondering whether we shouldn't hear some testimony and then have some committee discussion. But if you have a question that's at Sophie, go ahead and make it.
It's just a quick question. What did you say about the 2 years?
But under workers' compensation, there's statutory provisions that if you're able to return to work within 2 years, you can be reinstated, but your position may not still be open. So the way it works is if there's another suitable position that you're able to do.
Okay,
So you have a right to reinstatement for 2
Thank you.
years, which is not true for all states. I mean, that's something that under Vermont Workers' Compensation Board that we have.
okay, thank you.
Thank you. So our next witness on this issue is Megan Sullivan, who's Vice President of Government Affairs for the Vermont Chamber. Megan, come on up.
Afternoon, Megan Sullivan, Vice President of Government Affairs for the Vermont Chamber of Commerce. Thank you for Chair and committee for having me in today. I just want to start by giving some context on how we approach issues like this, because it's going to matter for what follows. The chamber doesn't take a bumper sticker approach to policy. We don't support or oppose proposals based solely on the intent. Even when that intent is well-meaning and aligned with values we share, our role, what we are here to do, is to dig deep into the details, talk with members who will be responsible for implementing the law and understand how a proposal will actually function in the real world. And that process has led me down some serious rabbit holes on this bill, as your chair can attest from all my questions. This includes how Vermont family and medical leave statutes interact with workers' compensation in Vermont, how job protection actually works under Vermont law, how these systems function in practice for injured workers, and whether this proposal does what I think the committee is intending it to do. And so I want to talk through some of what I have found in my thinking, in my conversations, and welcome questions throughout. Don't feel like you have to wait for me to stop. So I heard the comments, understand around the idea of this being sort of double dipping for employers. And I want to talk a little bit about how that framing might actually be oversimplifying what we're talking about here. So under Vermont's FMLA statute, job protection is clearly provided. It is intentionally more generous than the floor that the Fed set, and it provides defined period in which an employee's job is protected while they are out. Workers'
You
compensation
got a question?
Do you say provocative or provided?
provided
Okay.
in a provocative way. That's
Sorry, I was like, am I missing something? Okay, sorry.
no, you're good.
What is the period? What is the period of job
Protection.
and the nature of the
In
job?
FMLA,
Yeah,
12 weeks of job protection.
that is 12 weeks that you can still return to what?
Your job or an equivalent job. And that's key distinction that I'm going to talk about.
Okay, go on.
Workers' compensation serves a different purpose. It is an insurance-based system that provides medical coverage and partial wage replacement when an employee is injured on the job. What it does not do is operate, and I think I'm going to have a different take on this. It does not operate as job protected leave the same way that FMLA does. Vermont's workers' compensation statute, as you heard, does include reinstatement language, and that's important. But it's also important to understand what that language actually provides and what it does not provide. Under Vermont law, an employer is not required to hold an employee's job open during a workers' compensation absence. Reinstatement obligations arise only if and when the employee's inability to work ceases and when the employee can come back to work. So you have to be medically released on workers' compensation. If that occurs within 2 years, and even then reinstatement is to the first available suitable position, not necessarily to the same job, not necessarily to an equivalent job, and it's subject to multiple conditions and exceptions. It also, I believe the statute is silent on salary.
Have there been cases that have defined
I think
suitable?
there's a lot of cases around
Suitable.
suitable. You'll find there's a lot of workers' compensation attorneys who represent.
We might want to hear from it.
Go ahead.
Anita.
You were gonna say something.
Can I ask a question? From your testimony, and as I'm thinking of it, it sounds like PFLA or FMLA, I think at this point, we can just say FMLA for all intents and purposes, is actually more protective of what workers' comp.
Yes.
In terms of job,
Protection.
returning what you get when you
Job
return.
security, Yeah.
Yeah.
Okay,
Right.
thank you.
It's not as long a period, but it's more protection.
Right.
Yes.
Which during the leave period requires restoration to the same or comparable position with narrow exceptions that the employer must prove. So while both statutes use the word reinstatement, they work differently. Because of that, when FMLA runs concurrently, the employer is not receiving duplicative benefits. They're receiving wage replacement from workers' compensation and job protection from MLA, and those protections address different risks. Prohibiting concurrency doesn't eliminate overlap. It separates wage replacement from job protection. Obviously, Chamber of Commerce, I represent employers. And you will probably want to hear from workers groups on this, but from my rabbit holing, this distinction should matter to workers. As drafted, the bill would prohibit FMLA protections from applying during workers' compensation absence. In practice, this means that an employee injured on the job could receive workers' compensation benefits, but lack the guaranteed job protection during the period when they are actually recovered. Reinstatement would depend on future contingencies, including medical release and whether a suitable position happens to be available at that time. Today, Vermont's Family Medical Leave Statute provides a defined window of job protection during recovery. Under the proposal, that protection would not apply during a workers' compensation leave, even though that is often when the worker is most vulnerable. I want to address the idea that workers' compensation allows reinstatement for up to 2 years. So family medical leave is unnecessary or insufficient in comparison. I spoke with a Vermont Chamber member who provides voc rehab and medical case management to people who are on workers' compensation. So they're hired by the insurance company to do medical case management and insurance. And from what they have told me, and you could probably follow this up with Department of Labor for Vermont numbers, but nationally, the average time a worker is out on workers' compensation leave is 90 days. So that is important. In many cases, an injured worker's recovery period falls squarely within the 12-week window of job protection provided by the Vermont FMLA statute. When that leave runs concurrently, the worker has wage replacement and job protection during that finite recovery period. When concurrency is prohibited, that job protection may not apply at all during the 90-day recovery window, even if the employee technically preserves access to FMLA or later. That protection is shifted away when the time could matter most. Is that?
I'm with you,
Clear as
so I'm with you so far.
It's very clear, actually.
It's very clear.
All right.
Question is, wouldn't that be taken care of if we simply allowed the employee to, the employer couldn't require it, but the employee could do it?
That's not what the language says.
I understand. that. If you would like not to comment.
Can I
Yes.
ask a question
Go
of
ahead.
alleged counsel who is still in the room, who
Go
I
ahead. Go ahead.
has current language is employers may. They are not forced to. So if I'm an employer, I don't have to say you have to take FMLA, correct?
Correct. I get it. That's correct too. Okay, I got that. Okay. Okay, now I'm gonna let, I mean, that was a little bit of worker, but I'm gonna let workers say themselves. I'm gonna talk a little bit chamber-wide here. This has broader workplace effects that are worth understanding. When workers' compensation and FMLA run concurrently, there's a defined and predictable period during which wage replacement and job protection overlap. That predictability benefits everyone. It allows clear communication with employees, structured return to work planning, and more stable staffing positions. When leave is forced to run sequentially, the total period of absence can be longer and less predictable. An employee may be out on workers' compensation and then later begin a separate period of job protected leave. That sequencing can make it harder to plan for staffing in roles that must be filled consistently, including safety sensitive and essential positions. So these concerns are not about employees being able to take leave. They're about how the structure of leave systems affects stability when multiple statutory frameworks apply. And I will say, for some of the larger employers that I've talked to about this leading up to this testimony, there is also challenges around many of our larger employers have facilities in different states. Being the only state that would do this, it creates more and more of those inconsistencies of how you treat workers in one place, the laws governing workers in one state versus every other state. And adding those complexities, continuing to add those regulatory complexities makes it really challenging for those employers who are operating in Vermont. And they're already facing workforce shortages and challenging economic momentum, choose to continue to stay here. It was noted that there is no other state that does this. States often expand worker protections by adding leave, expanding coverage, or increasing benefits. What is less common is prohibiting coordination between systems that are designed to operate together. That lack of precedent is worth considering as the committee evaluates whether this policy will function as intended. And I want to talk briefly about federal law here and not make a legal argument, but just to provide context. Federal regulations on FMLA explicitly contemplate coordination between disability or workers' compensation leave and family medical leave. The regulation allows employers to designate qualifying disability or workers' compensation leave as FMLA leave and count it against the employee's entitlement, while also prohibiting forced substitution of paid leave during times of weight replacement. That permissive framework reflects a federal policy choice to allow coordination while protecting workers from financial harm. It does not require concurrency, but it does recognize concurrency as a lawful and common approach. A categorical prohibition on concurrency under state law removes that option entirely and moves Vermont away from a coordinated model that federal law assumes. I'm not asserting a legal conclusion here, just flagging that alignment between systems matters for clarity, predictability, and effective worker protection.
This question, does federal law permits concurrency? Does it make a difference about who decides whether it's concurrent, the employer or the employee?
I think Sophie has the language on the federal law, but it is the employer who would designate FMLA. I would probably recommend talking to Julio from the Civil Rights Division in the AG's office, who deals with FMLA. Okay, in closing, we support policies that help employees during times of injury, illness, and family need. Our concern is that this proposal, while well-intentioned, may unintentionally weaken job protection for injured workers, shift protection away from a period when it is most needed, and disrupt coordination between systems that address different but complementary needs. And would ask the committee to carefully consider how this proposal operates under Vermont law, how workers' compensation reinstatement actually functions in practice, how typical recovery timelines align with FMLA, and whether prohibiting concurrency achieves the outcome the committee is seeking. Thank you for the opportunity to testify. Open to questions.
I have more questions just not for you. I don't think that's a good, I was gonna say, I don't know if that's a good thing or a bad thing.
Thank you very much.
Thank you.
Well, before she goes, any other questions? All right. Next, Johanna.
Hello. Afternoon, everyone. My name is Johanna DeGraff-Reed. I'm the Public Policy Manager with Vermont Businesses for Social Responsibility. It's a pleasure to be back in the committee again. Last year, we came in to testify on the unpaid leave expansion bill. We testified in favor at the time. We recognize that this intended language is likely to try to address some of the conflicts or challenges that may have arisen in the context of workers' compensation with that bill. I don't want to get too deep into the weeds because I think that we've already gotten into the weeds now. So I want to make sure that we leave time for plenty of questions. However, I would reiterate the fact that at VBSR, we have continued to and will continue to stand by a universal paid family medical leave policy. The language that is currently being discussed right now is related to workers' compensation. So injury that happens at work, illness that happens because of work is workers' comp, not paid family medical leave. It is allowed to take them concurrently. The reason for that is because we want to ensure that folks are paid for their time. And some employers, as some of our representatives have noted, utilize the multitudes of ways in which leave access qualifies to ensure that folks are able to be paid during their time when they are on leave. It's not required. So there's been several questions about whether or not it's mandatory. It's not mandatory to take them concurrently. In fact, you're not legally allowed to take them or force folks to take them concurrently under Vermont state law or under paid family medical leave law. I want to note that the intention of the bill last year, which expanded leave for safe leave, bereavement leave, as well as for LGBTQIA employees and their family members, was not intended to extend to compensate, change, or in any way affect workers' compensation. Those are separate statutes, and it's really crucial that we keep them separate in the conversation. Because in complicating them, we create these kinds of rabbit holes of dialogue, right? Where we start to get deep into, well, whether we have folks who are dealing with pregnancy leave, is that the same thing as workers' compensation? If you are injured on the job, which is what the current language that you all are talking about today mentions, or you were ill because of a job, yes, the unpaid leave bill, which was passed last year, should not be utilized as a tool to not pay individuals workers' compensation. Right? That's the intent. I think we can all pretty much agree there. Whether there's challenges, as we all know, about ensuring that folks are able to receive pay that's necessary and also the legal right to return back to work. I think we can all continue to get deep into the paid family medical leave conversation, and we would continue to come in to talk about those expansions. But it's essential that individuals who are our worst actors are not able to use a leave expansion bill that was intended to ensure worker protections that was passed last year by this committee to loophole around workers' compensation rates.
Questions? I have a question. Which I'm just proposing something for your reaction. Supposing this didn't say an employer ... shall not count. Okay, supposing it said an employee who so elects may count.
What challenge would that solve?
Well, it would mean that an employee, if under the prior testimony,
Turn unpaid leave into paid
no,
first comp?
no, what it would do is, in other words, under the prior testimony, as I understand it, the FMLA is more protective, the Vermont Leave Act is more protective in terms of returning to job than
In terms of
workers,
returning to the same job.
same job than workers' comp.
Yes.
So what happens, how would you feel about language which essentially left it to the employee to decide whether they wanted to use that? They wanted them to run concurrent so they'd have the protection.
They're already allowed to use them concurrently.
They can just do that on their own. In other words, if they have workers' comp, they could just do it.
They can already use workers'
Okay.
compensation with paid family medical
Yes,
concurrently to ensure that they're paid during their time.
I'm revealing my ignorance. Okay, go on.
But not if they are injured on the job. That's workers' compensation specifically strictly by law.
Yeah, so it might help an employee who say is injured at home can go to their employer and say, I would like FMLA.
FMLA. If they're injured on the job,
It's workers' compensation, and they should not have paid family medical leave.
they cannot,
Utilize the
the
leave.
employee cannot utilize FMLA if they're injured on the job.
They should utilize workers' compensation,
They
which is why all businesses in Vermont are required to offer workers' compensation.
Well, they should, but do they have to?
They are required to.
But currently, right now, because an employer may, my understanding, and again, my philosophy for HR is very different than others, and I understand that. But an employee, I guess, could say, I'm on workers' comp, I would also like to use FMLA. I've never
Why
had
they
that.
choose
Well,
to do that.
and yeah.
When,
Why would that, because it's more protective of your job when you come back
yes,
than workers' comp is, because workers' comp is just about paying you while you're injured because of the job.
Workers' comp still holds your position for quite an extended period of time, or at least a comparable position.
a comparable position.
So, yeah, I'm just trying to understand why somebody would, what we're positing here. What is the,
Well, I mean, I'll tell you what, we can have this conversation later. It's not a question for I've exhausted my questions. Yes, go ahead.
With workman's comp, it takes a while until the person receives any benefit as far as being out of work, correct? The medical is paid immediately.
No, that's usually why businesses are required to have workers' compensation insurance. It can take a moment for the state to reimburse the business. However, most businesses are required to have workers' compensation insurance to ensure that folks are paid immediately.
So if you get injured on the job and it's going to be a short-term injury, is there a specific time where it kicks in? Let's say you're only going to be out for 10 days.
If you're out for a pay period or it's going to affect your paycheck, it should kick in immediately and it should be covered by your workers' compensation insurance. But I would defer to legislative counsel or another attorney about that to just clarify and make sure. But yeah, workers' compensation is legally required to cover you if you're injured or created illness at work,
And
even
just,
if it's a short period of time.
Ashley?
just another quick, like, short period of time, you might not miss any work. You might just have medical bills
Right.
too. So
Right.
it could be, you don't need any job protection.
Mary?
I just want to make a comment. When I did the workers' comp for the Central Vermont Public Service, the company would make up the difference or pay the employee if they were out their full salary until workers' comp. So there wasn't any gap. And I don't know if they still do it, and I don't know if other companies do that as well, but it was a nice benefit for the employee.
You're shaking your head no, other companies.
They don't do that.
They don't do
And
that.
that's not like a mandate. That's like you said, a nice benefit.
Mhm.
I don't actually know of any companies that do that.
Yeah,
Thank
my
you.
understanding of the intended language here today is to ensure that the unpaid leave expansion bill that was passed last year is not utilized as a tool by our worst actors to ensure that folks are not covered during their workers' compensation leave.
Mhm.
And we, of course, agree with that principle and want to ensure that folks who are out on workers' compensation, who qualify for workers' compensation because they're injured on the job or created ill on the job, they receive the workers' compensation benefits that they're duly entitled to. There's not a loophole that was created last year with the unpaid leave bill.
I admit to being confused. I thought the status quo, which allows concurrency.
Yes, it is.
If a person is injured on the job, they're going to get their workers' comp benefits regardless. The question, right? So there is no, am I
My
right that there's
understanding
no
is that
question that they're
there's-
going to get their workers?
That's the hope, but my understanding is, I guess, that there are some folks who are interpreting the law from last year to be perceived as a possibility for unpaid leave. I don't think that that's something that's commonplace. I think that's a worst actors scenario. And I think that if this is what's necessary by the committee to address any challenges from the unpaid leave bill last year, just for clarity for employers and employees, I think that that's totally reasonable. But I want to make sure that we understand that workers' compensation is workers' compensation and should not be impacted by the
Emily,
bill that was passed last
and
year.
then Ashley.
I just want to point out that actually was not a catalyst of last year's bill, that this was brought to the attention of various people from an organization or from employees before any of that happened. So it doesn't have to do with what we did last year, confusing things. This was already a loophole that people had found previously and had brought to the attention, and this bill was drafted in concurrence.
You were going to say,
Ditto.
it ditto. So.
I just want to
I'm
be
sorry.
clear because I don't want people to think that anything that we did muddied anything up, because that's not accurate at all.
The example being used is somebody who, say, is injured at work,
Right,
they're forced to take FMLA during their workers' comp,
right.
and then in that, they're able to come back and it's someone who's pregnant and then cannot use FMLA
Right.
for
Right.
their leave.
So let me clarify to see if I am right. Okay, I'm just trying to understand this. Somebody who's injured on the job and working for an employer who uses concurrency. So that's me. I'm on the job, I'm injured, and so I'm injured badly enough. My workers' comp will be operative even with concurrency. So I will be paid for while I'm gone. Is this right, Sophie? I'm paid while I'm gone,
Two-thirds.
two-thirds, and I have my medical bills paid. But also my 12 weeks of family leave, my Vermont my parental and family medical leave 12 weeks are running as well. So if I'm gone for, let's say, 9 weeks, when I get back under concurrency, when I get back, I've had my full benefit from workers' comp. But when I get back, I only have 3 weeks of family medical leave left, right? And I may have enhanced rights, the FMLA, right, the Vermont FMLA. I may have enhanced rights to return to my original job that I wouldn't have under workers' comp, but I've lost a lot of my family medical leave time. Yes.
Can I throw the other scenario out?
Well, first of all, is that right? Is that right?
It could, if you were taking both concurrently. that
Yes,
would be-
I'm just saying in a concurrent
In
world.
the other situation, though,
You mean the situation where they're not concurrent?
you go out on workers' compensation, the next day that employer fills that job, you're released.
Yeah, then
You get medical release and you say, I'd like my job back, and the employer says, what job? We filled that job, we have nothing suitable for you.
right, the difference is the job benefit. I
Right.
understand. But it's not as if you lose your workers' comp benefit. You get that. You just lose time, FMLA time. Right? Okay.
That's correct. And I just want to note that the specific language that we're speaking about today is about unpaid leave. And
Yes, right. It's all unpaid. Yeah, it's unpaid. Yeah. Yes, Lenora, you have a question of the witness?
No, it's okay.
Okay, well, we have a little time, we can have discussion. And I think I'd like the committee to discuss any thoughts they have, but also who else we might have in. Yes,
I have a question for Sophie.
thank you very much. Well, before Johanna gets to leave, does any have a question for her? You know what? If you have to exit the room, you can, but you can also sit here and just be ready to answer questions. Okay,
thank you all for your time.
yeah,
And happy to come back in.
okay, all right. Go ahead.
I truly don't know the answer to the questions I'm about to ask you. Um, it's kind of a two-folded question. I'm going back to our original conversation where the thought of benefit premiums, covering benefit premiums kind of came up in our committee in our original conversation about who's paying those premiums. And I've just kind of been stuck on that as we've heard testimony today, and it's just kind of led me down an HR rabbit hole, which it sounds like this bill has led several individuals down. Normally, actually, sorry, let me rephrase this. To be eligible for FMLA or PFLA, you have to work a certain amount of hours within a certain amount of time. So 12 months and it's $12.50. In a scenario where I'm an employee, I have been injured, it's a serious injury, I'm on workers' comp, and I am not working, workers' comp holds my position, or in this hypothetical, I know that I will have a job still at my employer. And I hit that 1 year mark or that 12-month mark where I have not worked. Does my eligibility for FMLA or even benefits come into question? Because usually you have to work a certain amount of hours to be eligible for either one of those things. So is that going to affect?
Good question.
Does that make sense?
Yeah, and so my understanding is, yeah, that your eligibility is on a rolling basis, so if you haven't worked,
Yeah.
I would want to double check that. Under the PFLA, as far as your health insurance goes, I believe the employee still needs to continue to pay their share of the
Yes.
premium. And I think that's true under workers' comp, but again, I would want to double check that.
But the question, as I understood it, was to be eligible for FMLA, or let's just say FMLA, it means Vermont, but you have to have worked a certain number of
That means
hours.
federal.
Yeah, okay.
Well, either one.
Either one. Okay.
You have to, I mean
Unpaid
Vermont.
leave,
Yeah,
job security.
to be eligible for that, you have to have worked up to that point a certain number of hours.
Right.
Okay, does time spent not working because you've been injured and are on work comp count towards those hours or not?
I would want to double check it, but yeah, usually if for whatever reason you stop working, you decide to go part-time or something, you would then lose your eligibility for PFLA. I would want to just double check, but I believe that, yeah, they just look at the number of hours that you've worked, and if you haven't worked the number of hours that's required for the year, then you're not eligible for PFLA. But again, on the other hand, if that entitlement continues, right? So if you take some PFLA, you take 2 weeks of bereavement leave in a year, once you get to that next 12-month period, you get that time back, right?
Right.
It's not, it restores itself.
Can you
as
just
long as you
check out
continue to
when,
be eligible.
put that on your list of questions?
Yeah,
But
Go on.
it does, yes, it does restore yourself, but if you're not even working, it can't possibly restore it.
Right.
It's correct?
right.
Okay.
Because I think that's what I think. I would just want to double check, but that's my understanding is that
So,
you have to have been
if
at
I'm
13
injured-
hours.
Yeah.
If I'm injured and I can't work, and then my dad dies and I want to take bereavement leave, I might not be able to. But of course, I'm not being paid, it's unpaid anyway. So the only thing that would matter to me is my right to come back to my job, which I would still have under workers' comp, right?
But if you haven't worked.
Well, did your job might have been filled while you were out on workers'
Right.
comp?
I now have other questions.
Go ahead, please. Actually, I
I'm
think
so
these
sorry.
questions, no, don't apologize. These are important. Some of us are pretty ignorant when it comes to these issues, and I think it's important for us to understand. I also would like, we have till 2:30. I would like amongst our questions and discussions to come up with a list of who else we want to hear from, if anyone. Unless you feel like, I know what I think and I don't care what anyone says, and let's vote. Okay, let's see. You have questions and then you're on deck.
My other question. Can I bat to Mary? Because it left my head completely.
Mary, you've been,
Okay,
the baton has been passed to you.
Thank you. I just want to say that when my husband was very ill, I worked for the state, and because I didn't work 30 hours, I could not take any paid or leave. I could.
You can take any unpaid leave.
Yeah, well, no, I couldn't. I could only take
Whatever
like
you
the
declare.
time off when I needed to. And for funeral, it was time off that I needed to take unpaid. but I had a wonderful boss and he was great and just, but, yeah, I think it's, if you're on workers' comp and you come back, if they haven't filled your position, you're back in your position.
Assuming you're not so injured you can't continue to do
Right.
it, right? But
Right.
anyways, yeah.
And if they filled it with a part-time, you know, I don't even know if they still have Kelly Girl Services, somebody who just comes in and does the job. A temp, they would let that temp go before you, right? Okay.
And the other piece is just, I mean, again, these leave laws are incredibly complicated. I mean, there's a bazillion regulations at the federal level around the Federal Medical Leave Act, which again, I think we don't have those separate regulations. So again, we'll look at the FMLA to fill in gaps where our leave law doesn't cover it. Now, the other thing is that you also might be entitled to leave under collective bargaining agreement or your employer's policy under their handbook. So again, an employee gets the benefit of whatever the most generous leave policy is that would apply. But these are super, super technical provisions, particularly the FMLA.
I remember my question.
That's what I,
And it was because Mary said something, so I'm very happy I sent the baton that way. Supplemental pay, so if I'm on FMLA, it's unpaid, however, I can choose. My employer can say, you have to take any vacation, discretionary, sick. And that can supplement my pay. Is there any stipulation in workers' comp policy that says, like, if I'm on workers' comp, I'm only getting 2/3?
Right.
Can I then use my available PTO, CTO to supplement that? Because I know I can with
I've been told
FMLA.
no, that
For workers'
medical
comp?
is only for medical.
no, but if it's PTO, it's everything.
Well,
Oh, if it's
But-
all, okay. Well,
Yeah, that's the point of PTO.
I mean, I don't think there's anything in the statute around that. I don't know if that's something you could discuss with your employer, like I've got a bank of leave.
yeah,
I'm only getting 2/3 through workers' compensation. I'd like to access, the paid leave that I've accrued. I don't know. I don't know what the answer to that is.
Okay.
But I could check and see.
Yes,
How does this affect someone when they're on workman's comp as far as their medical insurance through their employer?
So your medical expenses for your work injury would be covered. What I don't know is, what I believe, but I would want to double check, that was what we were talking about before. If you pay 20% of the premium, does the employer still have to pay their portion of the premium while they're out? I believe they do, but I would want to double check on that.
Right, because the medical insurance could be for the family as well
Right,
as the person.
So I think you would still have to do that, but your medical bills, so instead of, where you might have a copay of X amount or whatever, that's all taken care of by workers' comp. They're not paying medical bills associated with your injury.
Right, right.
I have a question. Do you have any comment on Megan's non-legal opinion that there may be a conflict with federal regulations or other workers' comp law which contemplate concurrency?
So I did look at the regulation that Megan had shared, and that's dealing with when you can substitute paid accrued leave and what happens with paid accrued leave that you've accumulated. And this is not that, right? This is talking about our unpaid leave. So I don't believe this, what's proposed in this bill would conflict with the FMLA. I think there's an issue that was raised in terms of could it have an unintended consequence for workers? And I think there probably are some hypotheticals where maybe that a worker could be at a disadvantage if they, are out on workers' compensation, and they're not, their job is already being filled, if it's not running concurrently. I think for the most part, when an employee is out on FMLA, again, that there's up to 12 weeks of unpaid leave in that situation. So I don't know how common it is for an employer to go ahead and just fill that position right away. I mean, again, the statute provides there are certain circumstances when you can do that if you have someone in a unique position or whatever, but typically I think they go down the route of finding a temp to come in to fill while someone's out on maternity leave or whatever it might be. But I can't rule out that there could be some hypothetical where that has an unintended consequence. But I don't think it conflicts with the FMLA. I think it's the goal of this is pro-employee in that if it allows an employee who's out on workers' compensation that works for a large employer to be able to come back from their workers' compensation injury and still have access to 12 weeks of unpaid medical leave. So if they've been out on a workers' comp injury, they come back, their wife is having a baby and they want to take family leave for that, they still have that open to them. Whereas if it's run concurrently, which was what you were illustrating before with your example, they might come back and they don't have access to that.
Right. Let's say, for example, that I am single and my parents are long gone. And I consequently don't imagine that I'm going to use FMLA. The Parental and Family Leave Act.
But what if you get in a car accident?
But I'm injured on the job. And I know damn well that my job, I have a very special job, and if they hire, pretty soon they need to hire someone, so they're gonna hire them. And then I know that it's a small company and I'm gonna wait a long time before a quote suitable job opens. Would I want them to run concurrently in that case for?
The Parental and Family Leave Act provides that upon return from leave taken under the subchapter, an employee shall be offered the same or comparable job at the same level of compensation, employment benefits, seniority, or any other term or condition of the employment existing on the day leave began. This subsection shall not apply if prior to requesting leave, the employee had been given notice or had given notice that the employment would terminate. This subsection shall not apply if the employer can demonstrate by clear and convincing evidence that 1, during the period of leave, the employee's job would have been terminated or the employee laid off for reasons unrelated to the leave or the condition of which the leave was granted, or 2, the employee performed unique services and hiring a permanent replacement during the leave after giving reasonable notice to the employee of the intent to do so was the only alternative available to the employer to prevent substantial and grievous economic injury to the employee's operation.
So that last one could be used in that situation. Yes.
I just have a suggestion, because I had someone ask me, he was a architect engineering, and he said if his draftsman was out, he would lose 30% of his business. And my suggestion to employers is to cross-train. Because the 2 offices I worked in, whenever someone was out, we just pitched in.
You can't cross-train some.
I realize that,
Yeah,
but,
certificates and licenses and degrees, some of them don't cross-train as easily as others.
right, I know that. But also as the owner of the business, you should. So,
Is,
Have 2 licensed.
yeah.
could we ask for a moment? Sophie, do you have thoughts on more witnesses? I mean, one of the issues raised, do we want large nonprofit institutions like the colleges or UVM or others testified? Does this apply to them? Is this an issue that they would care about?
I don't know. I mean, I think there's, again, Megan represents for employers. I don't know if there are other groups.
Mark,
Yes.
You know, after listening to this conversation, and I'm not obviously in the clearest state, I'm thinking we might want to just, after this conversation, let's just take a minute and think about a few things. I'm just wondering, I just don't know if this may be more of a commerce situation. And I just want to think about that a little bit as a
Well,
group
we
or,
could, do you think, I mean, I was planning to talk to Marcotte.
okay.
Would you like to be part of that?
Or Ashley can, doesn't matter. I just
Okay.
think, it may be both, but it may be some of the lift in there. But if we do, if we do end up staying, I have some ideas of witnesses. I just want it before we, what is it, the cart before the horse? Is that right?
I can certainly talk to Marcotte before, we're not going to schedule more testimony in the immediate future. We're pretty booked.
Right. I just know that we have a lot on our plate right now.
We do, right, I know.
I just want to think about it, but not ending it, just circling back. But if not, I can help with some witnesses if we decide.
Okay. And I'm sure others can as well. Any other comments or questions before we, yes, Tom?
Just to point out, Richard Wabi of the Associated General Contractors of Vermont submitted written testimony that's in the folder for today. That explains how this kind of interplays with the sort of scheduling you have to do on construction sites with contractors. And it's worth reading. And I'll wait for some other time to explain again how this affects a small shop of 10 in a way that it doesn't affect a shop of 50 in terms of revenue and overhead. And I'll come back to that some other time, but I am a little bit concerned in a wider sense with the number of like big box employers, everything from manufacturers to supermarkets, who customarily hire only part-time because it's too expensive and there's a lot of kids working 30-hour-a-week jobs with no benefits who are never gonna, they're just gonna take 8 of them to rent an apartment. And the more expensive we make it, the more difficult we make it to hire them, the less likely there's going to be a 40-hour-a-week job. So there is a certain portion of the workforce that this kind of keeps them under that threshold because employers will look at it and say, "Oh, I'm just not going to hire full time." So it's just a cautionary thing to bear in mind on the wider economy.
Any further thoughts? Yes, Ashley.
This is just a thought, do with it what you will. A lot of employers don't even touch their workers' comp. They have a third party where someone falls and gets hurt and they immediately call the nurse's hotline. And the third party handles it, and then they say, the employee might say, hey, I won't be at work, here's my doctor's information. But the employer's pretty much taken out of it. So
You mean they have, be more specific.
so I've worked for an organization that consider it like an umbrella organization where it's satellite offices. It's all covered by one workers' comp. Someone gets hurt. Again, let's say it's that ice slipping. They call it's like a nurse's hotline and say, this is what happened. That nurse will say, okay, you need to do X, Y, and Z. It might be you need to go to the hospital. And then that employee says, okay, thank you so much. They hang up, they follow those instructions. The nurse's hotline then as I'm saying this, I am now fully down the rabbit hole. And I understand why it came here because we have FMLA, PFLA, like leaves of absence. I'm not sure if we can do this bill justice separately from
Right,
from
okay.
commerce. Like I would almost feel like I would rather them work on it and then we do a drive-by.
Okay, well, I would definitely talk, you and I can talk to, so that's okay with the committee. We'll both go over there and talk to them. Or maybe just our vice chair. See, yeah, I got the thumbs up from Emily. All right. So what I'm gonna do is suggest at this point, we take a break. I thank you to our two witnesses for your patience and wisdom. And we're gonna take a break and return here